Sure, sure.
I'd like the court to know I believe we may have some law students in virtual attendance this morning to kind of maintain some sense of normalcy. Of course, if we were doing this in person, you'd have already known that. So I thought it merited mentioning. Whether or not they're here, I can't confirm. So that's a whole separate issue. 8 issues. I'd like to touch on 2 briefly, and then primarily focus on 2 others. The 2 I'd like to touch on briefly, if I may, court permitting, that I consider case dispositive of the 2 really big issues. The fact the current felony is unconstitutional, our first issue, and that the ineffectiveness is apparent on the face of the record, our 5th. Realistically, I don't think the court's going to declare the felony portion unconstitutional or resolve the effectiveness of counsel on direct appeal. But if you did as to either of those, it would require reversal. When I say those 2 are case dispositive, it's not to the exclusion of the others. We maintain that all the issues are, but the effect of the other issues when taken together, if not on their own, is such that we get to that reversal as well. And having acknowledged that, I'd like to focus on the hyper-specific opinion of 25.8 days of torment, which is our second issue, I believe, and the Gamble's excluded bias testimony, or testimony as to bias. But again, that's without abandoning any issue briefed. And of course, I'm here to talk about whatever the court would like me to address. There are 2 categories of problems, I think, about the specificity of 25.8 days of torment and the harmfulness resulting from that specific opinion that the vet was permitted to give. Mentally, I consider some of those red flag issues, and then I consider the remaining problems we briefed as to really being the heart of the law as to how 702 wasn't satisfied here. I mean, some of those red flags quickly include things like, I'm not even sure how long 8/10 of a day is. That's awfully specific. And I've billed in 6-minute increments on and on, or 1/10 of an hour increments off and on for a very long time now. And I'd have to get a calculator to figure out how long 8/10 of a day is. It's unclear to me about the conversion process from millimeters to imperial. I believe the vet testified that she did so without any further elaboration. I have some anecdotal comments on that, but they're not in the record. I'm gonna walk away from that. It's not clear who translated this article into English, and I think it's reasonable to say that one thing we all know from reading expert testimony over and over and over again is that they like ranges. Probably for the reason that they're knowledgeable enough in their fields to know that X event was likely to have occurred somewhere between this long ago and this recent. They don't like being boxed in on specifics, much less 8/10 of a day. In fact, a general rule, I think, is that the more specific somebody is about something technical, the less knowledgeable and reliable they start to sound. Like, I'm sure you've seen when witnesses can't seem to answer yes to a yes or no question, they get exaggerated and they say absolutely, to the point that it starts to make you wonder who it is they're trying to convince.
Mr. Upson, much of what you are arguing over the last minute or so seems to be fodder for cross-examination, isn't it?
It is, Judge, but what's unique about that expert opinion and why that argument failed below and in Appellee's answer brief is because that really goes to an ultimate issue upon which we need those indicia of reliability codified in 702 before that bell ever gets rung.
Well, so it sounds like your ultimate argument is lack of foundation, but you're not really arguing that.
Well, and I perhaps not to my credit, wanted to start with the generalizations and the red flag, what I consider the warning signs, before getting into really the substance of the fact that the state utterly and completely failed to meet their burden to provide that foundation here. As to the specifics and the science, I also have a relevance concern because I'm not sure on a strict liability crime, 25.8 days provided anything this jury needed on any material fact. And to the extent that the state had the burden to prove that the suffering was excessive or repeated, it's not clear to me, and we would argue therefore it was error to be so specific, that the vet couldn't have simply testified, this injury appeared to me to have been present in this condition for some time. And I think that alone would have satisfied. But at the point the opinion was given, this animal suffered for 25 days without sufficient indicia under 702. And here I think Judge Silverman is the gist. And I was not trying to beat around the bush. I think you have to look at all of it. And I do have those other concerns that I consider the red flag concerns. It's not at all clear from the record what qualified this veterinarian to testify as to pathology. Her testimony was that she's a vet who treats living animals. Can you imagine a general practice medical doctor giving expert testimony on an autopsy? Or would you expect to hear from a medical examiner qualified in forensic pathology? And perhaps also to your point, Judge Silverman, not a lot of those specifics are contained in the record. So it would be reasonable to ask which of those things I just said actually came out of defense counsel's mouth at trial, to which I will say it was the state that bore that burden. And counsel did sufficiently argue it's just not there. Her qualifications, the sufficiency of the internet article on which she relied, her application of the methodology contained within that article, it's just not there. And the state had that burden, at least in courtrooms where trial judges don't declare the testimony relevant even before they've heard the argument.
But she did say during the proffer that based on her experience, the tissue of this dog showed granulation, which is, as I understand it, an effort to heal over the wound. And then she said that all granulation tissue heals at approximately the same rate, no matter what kind of an animal. And I think she said as long as it's a mammal. And so she seemed to say that based on her own experience. Is that right?
I believe that's correct, Judge, which is why I think testimony like, based on my training and experience, this injury appeared to have been present in this condition for some time, would have been sufficient. And would have satisfied the state's burden. As to the excessive or repeated component required. My concern, though, is that once you ring the bell, 25.8 days, this dog was tormented, 25.8 days, based on, and I appreciate it was her opinion. It's not clear to me the methodology or the application of the methodology to arrive at the conclusion that it was in fact as long as she was permitted to testify that it was.
Mr. Upson, wouldn't that be that kind of granularity of attacking a proffered expert witness's testimony? Wouldn't that be properly raised in a Daubert challenge, which didn't happen here?
An interesting point I wish I knew more about, Judge. Candidly, I can respond to the argument the state made at trial and repeated on appeal, and the examples from like Booker and Durling cited therein about the type of challenge, and just to make sure I don't misunderstand, it's a timeliness of the objection, Judge? Is that essentially part and parcel?
My concern is that the way those kinds of challenges have to proceed is that you have a formal motion that's, that lays out, this is what it's going to be, and both sides get to kind of bring in their folks to talk about whether or not this meets the applicable standard or not. And it's typically done as a standalone separate evidentiary hearing. And that didn't happen here. And the reason that has to happen that way is because it is a pretty significant kind of challenge. And it does take, those things can get pretty wonky and take some time. And so trial courts are supposed to focus on those when those issues are raised. And what I'm hearing sounds more like there's a question about whether or not this is just even acceptable science. And you saying that the judge should have stepped in and not allowed it, to me that sounds more like an unraised Daubert challenge.
Notwithstanding the fact I may not appreciate the nuance of what the landscape under Daubert, it's not going to stop me from, I have answers for you, Judge. First, when the state brought that up at the trial court level, and I'm paraphrasing, of course, whatever's in the record is what is in the record, words to the effect of, this witness was deposed by the defense months ago, and they've just now here at trial, are they complaining about this? But they never actually, and I briefed this, they never actually asked the judge to make a timeliness determination. And in fact, in the answer brief, they seem to have waived that. And I don't have the exact page, and I may be reading too much into it. I'm sure we'll learn more about that. Of course, the court can read the answer brief on its own. That regardless, the court denied on the merits, however. So the state said, could have brought this up before, should have, this isn't the time, didn't press for a determination on that, argued on the merits and let the court reach a merit determination, which we would argue is a lot easier when the court has already preemptively said, I'm sure it's relevant, before the court's heard any of the argument. Having said all that, I don't know, the court clearly does, that such a challenge is as prevalent in cases where the expert hasn't provided a report. In its answer brief, Booker out of the first, and Durling, upon which Booker relies, the procedure in Durling, even though Durling was a Fry situation, in both those cases, factually, those experts had issued reports well in advance at trial. Don't believe this expert did so. I think it probably matters. Judge Northcote, were you gonna?
Well, I was going to say, but take the expert's deposition. You know what the expert's going to opine to, and that gives you the same opportunity as a report would it not?
Well, and I guess
to file the motion to exclude,
should have, or certainly would be reasonable to expect that and to make that argument. However, to go back to Judge Lucas's point about when I hear Daubert challenge, I hear two capital letters. Daubert, obviously, because it was a proper name in a case, but challenge with a C, maybe akin to how we think about stand your ground, which is a terrible example since we know you can bring stand your ground before and at trial. So just forget I came up with that. But it's a separate thing. And I appreciate the question, Judge Lucas. Should this not have been resolved prior? I'm simply saying that it's our position that, well, first of all, since Booker and Durling, upon which the states relied in the answer brief, not at the trial court level, I guess I'm glad we're not in the first, for starters, because both of those are, which one can say on a daily,
lots of reasons,
which one can say on a daily basis. And I should have checked. I don't think I have anything pending in the first right now. That not that they watch or any of you are gonna tell them, but I think it's probably a distinction, Judges Lucas and Northcote, the fact that the reason in experts, you notice the expert The expert comes up with a report. We all get to look at it. You give the report to your expert. You get access to the things that, I mean, that's a whole separate process that this record does not support happened here. And if there was an end run, if there was a way around that that says, ah, yeah, you got to depose him, good enough. I think that's kind of probably part of the purpose. A report is a thing that has to have a scientific basis that counsel doesn't have to know the science, because counsel can hand the thing to counsel's expert and say, does this make any sense to you? And I don't believe this record supports that any of that happen. And again, that's all in a context where I'm going to acknowledge, I don't want to say concede, but had the vet only come in and said, based on my training and experience, that appears this injury had been like that for some amount of time. But wow, 25.8 days?
Well, Mr. Upson, I mean, reading through the closing arguments, it's not like the state hung their hat on the specificity of what the veterinarian testified. I mean, I think it got 25.8 gets mentioned like in passing in their first pass and said, so at least a month. And then I think they just kind of, there's this freestanding thing in rebuttal where they said 25.8. It's not like they were hammering the scientific certainty of this expert's opinion as to the length of time in closing. I know that's not the be all and end all of the inquiry, but it sheds some light as to whether or not it had some effect here, don't you think?
Yeah, Judge, you're absolutely right that had they done so, that would have been front and center in my brief as well. I mean, look at how they exploited that throughout.
Yeah.
I don't think experts are different though, and I think the state of Florida, the jurisprudence has traditionally treated either under Fry or Daubert. That's special. That's special testimony, which is not a reference to the Florida, trivia that's fallen out of my head in cases that aren't briefed. But interestingly, Judge Lucas, our sixth issue on appeal was the state's theory of prosecution, which, to paraphrase, is that Mr. Carbajal Garcia is kind of not a likable person. So I did brief the error in the state's theory of the case that they did pound on early, during, and at the close. Because not really being an unlikable person, not really an element of the felony, even if it weren't a strict liability, even if it were a general intent, even if it did require some knowledge on his part. But primarily in response to your concern, it's our position. Experts are different. Experts are special. That's why we have those thresholds that have to be met of reliability. And as I think I said in the initial brief, just because we've gone from Fry to Daubert and it's widely considered to be a lower standard doesn't mean it's no standard at all. And while I acknowledge and appreciate that virtually all of the argument I'm making as to why it didn't meet 702, none of which came out of defense counsel, it's sufficient. The defense counsel said the state bears the burden and the state hasn't met the burden. And again, not for nothing, this trial judge said offhandedly, I'm sure it's relevant, before I've even heard any of what any of you have to say.
Mr. Upson, you are at your 2-minute mark.
It is perfect timing, Judge. I knew it. I wish I had planned that, and I had said I want to talk about one issue, not two, because clearly I haven't talked about the other. Accordingly, we asked the court to vacate and remand for discharge, or in the alternative, imposition of the misdemeanor, or in the alternative, a new trial.
Thank you, Mr. Upson. Mr. Phillips, you're up.
May it please the court, counsel, good morning. My name is Chris Phillips. I represent the state of Florida. Just to dive in where Mr. Upson left off, the big issue that we spent the majority of the time on this morning is the ability of Dr. Ferguson Morrison to provide her expert testimony as to the approximate age of the injury. I would start off by saying her testimony was a minimum of 25.8 days. Mr. Upson had made some concerns about the specificity in which she provided that. That was the minimum. So anything beyond that. So there was an inherent range that could be interpreted based upon her testimony. And just to jump in what Judge Lucas was saying, this wasn't a central theme of the state's case, and that there was no Daubert hearing. And as Judge Northcutt indicated, the deposition was conducted 7 months prior to. Everyone knew exactly what her testimony was going to be. It wasn't until she was about to be called in the stand, the jury was ready to take their seat, and then all of a sudden this issue comes up. So there's certainly issues there. She did provide the testimony during a pretty lengthy proffer where both sides were permitted to inquire, including the court, that she is a veterinarian, has been for 22 years. She's seen and treated over tens of thousands of animals, and went on to rely upon a study that was conducted in Europe based upon the granulation that Judge Silverman just talked about of all mammals. They have the same approximate rate at which the skin cells attempt to heal themselves. And based upon that study, she was able to articulate exactly what, or the approximate age at which the injuries occurred. Now, Mr. Upson makes it some sort of concern about the conversion from inches to centimeters, and I think it would be a pretty simple mathematic equation that 1 inch equals 2.54 centimeters. I certainly remember learning that early on in my education. So it certainly isn't some very technical translation that needs to occur, that there would be another expert that would need to come in and provide that. And as Judge Lucas touched on, it wasn't a central theme of the state's case, but the state did have a burden in this to show that the animal did sustain excessive or repeated infliction of unnecessary pain and suffering. And that information was provided to the jury. And I don't believe the state's contention is that there was any error based upon her testimony as an expert and the proffer that both sides had access to inquire in the court's ultimate ruling. And even if there is any sort of error, the only piece of information that the court could possibly find as being an error is that 25.8 days. And the state's belief is that would be a harmless error, and that the state did meet its burden of proving beyond a reasonable doubt that that error, if it was to be found so, didn't contribute to the jury's ultimate finding of guilt. There were
Mr. Phillips, I will tell you that I am a little troubled by that argument, because that is a very significant, very definitive period of time that the veterinarian testified to. And as you said, that is that a period of time is an element that the state needed to prove. So how can that not be a central part of the state's case, and one that goes to the heart of the jury's determination?
Well, respectfully, Judge Silverman, I would say the time period is indicative of the continuous pain and suffering and excessive suffering that the dog sustained, but isn't a required element. The injuries speak for themselves. There were photographs that were introduced into evidence, one specifically with the ruler into the 1 inch deep wound to the dog's neck, and then also by 5 inches long. So if that testimony is somehow excluded, there's certainly other evidence that was introduced through the state's case that would allow the jury to make the finding of guilt. The 25.8 certainly was something that came up and was based upon a scientific peer-reviewed journal that was published in Europe, and she utilized that to approximate the age of the injury. But the injuries themselves and the wounds, and I'm sure the record will speak for itself, and if the court's inclined to look at those photographs, there's certainly, based upon that, there would be sufficient evidence for the jury to view that and make the necessary findings as required for the repeated infliction, unnecessary pain or suffering of the animal. So I hope that answers your question, Judge Silverman.
Thank you.
And there were several other issues. The court doesn't have any other questions as to that. I just want to be able to have the opportunity to touch on Mr. Upson's other issues. Briefly, the constitutionality of this, I think Mr. Upson, I don't want to say conceded, acknowledged the lengths that which he's asking this court to find that statute to be unconstitutional. Certainly the state's contention is that it's purely the quintessential legislative function in order to determine the appropriate elements of an offense. And even if there is no specific indication of a mens rea element, that the legislature has that within its purview to construct statutes without having that spelled out. I would say that it's the state's contention that the appellant is misinterpreting the statute, and throughout the brief and then a little bit this morning described it as being a strict liability. The state's contention is that it's not, that it is in fact a general intent crime. It doesn't necessarily need to show the specific intent of the injury that occurred, but does need to show that the appellant, Mr. Garcia, in this case, took the action or inaction of tying the dog to the basketball pole and virtually having a willful blind eye to the dog's condition on a daily basis. So he certainly admitted to law enforcement, also to the animal control officers, that he is the one who tied up the dog, and the facts speak for themselves, that it wasn't a normal harness or a leash, that it was a type of a lead or a strap that was tied in a knot around the dog's neck. So in this situation, he admitted to tying the dog to the post. As a result of that specific action, he failed to take any corrective action to remedy the issue in the short term, whether to remove the lead from the dog's neck, or in the long term over the several days or weeks in order to help prevent any sort of injuries that the dog sustained as a result of that. So it's the state's contention that the statute is constitutional on its face. So we respectfully request that all relief be denied on the appellant, and that the judgment sentence be affirmed by this court. As to the ineffective assistance of counsel, certainly that would be an issue that would be more cognizable during a lengthy evidentiary hearing, and certainly is not specific on this face. The appellant does make some notes again that there was some concessions during opening statement and then throughout the case, that he did this thing, and the argument from appellant is that he conceded the elements of the offense. And again, the state would contend that that is not true, that there was more than just the own a dog and that the dog suffered. There's certainly more requirements that go into it. The next step is beyond that you own the dog, yes, that the dog suffered, yes, but that was as a result of your failure to act, as contemplated in the 2013 statutory amendment. So one's not able to just purposely inflict the pain on an animal, but now is, if there's a failure to act, that as a result of your failure, that the dog sustained the unnecessary and repeated infliction and harm. Now, as to issue 6, as a bad guy, there were some statements throughout that the state, actually the attorneys went through several times where they said, so we're not here to judge whether you're a good guy or bad guy. And any sort of statement that he was leaving at 5 or 6 in the morning and not returning till 10 or 11 o'clock at night were just very reasonable and pretty much expected commentary on the evidence as presented. That became one of the central themes of the defense. Was he is a family man, he's got family, he's just started a business, he's busy, he doesn't have time for the dog, So those were just commentaries based upon his own statements to law enforcement during a recorded Mirandized interview, where he said, I've just been too busy to care for the dog. So those were just very realistic and logical commentary on the evidence as presented. And Mr. Upson briefly talked about the gambles. In this situation, the trial court did properly allow the gambles to provide testimony as far as their observations and interactions with the dog, up to and including the day before or the Friday before the dog's removal, and then properly excluded their ability to testify, in essence, speculation as to what these other officers had said or what they thought they were trying to get out of the gambles, clearly hearsay. And there was an argument that it was used for impeachment, but those officers who were out there on that particular day never testified at trial. So the trial court did use its broad discretion and exclude those portions of the Gamble's testimony because it wasn't frankly relevant, it was hearsay, and it was speculation, and they should not be able to comment upon any of the other testimony of the other witnesses. And again, these officers in this case didn't even provide any testimony. So Your Honor, I've touched on all the issues that Mr. Upson has brought to this court's attention. If there's no further questions, the state would rely upon its written brief and request that the court deny appellant's requested relief and affirm the trial court in all its findings and maintain the judgment sentence as entered.
Thank you, Mr. Phillips. Hey, Mr. Upson.
Thank you. Mr. Phillips had the unenviable job of having to argue somebody else's brief, and kudos on that. Great point about the testimony about the minimum, the floor being 25.8. And so to the extent the record supports that, and I'm sure it does on Mr. Phillips' representation, then I recede from the assertion that she didn't give a range. Same argument from us. same harm. But great point, and I appreciate that. I also appreciate the conversion from imperial to metric and back and forth ought to be pretty simple. The anecdote that I withheld, I'm going to do it now. In 1999, JPL cratered an orbiter into Mars because someone failed to correctly account for the conversion from the European Space Agency to whatever JPL. I don't know why they weren't using so far beyond the page, but it ought to be pretty simple, and yet sometimes it's not, even for people a lot smarter than I am. As to all of a sudden, her opinion was challenged. I would take issue if it's clear that if the state of the law is clear that experts, you've got to object early and often. You can't wait till trial. Then so be it. I have concerns about requiring defendants to take certain steps months in advance of trial that informs the state about things that defendants traditionally haven't had to inform the state about. And I don't believe it's the current state of the law. I do believe it's a strict liability crime. I mean it. I will die on that hill.
Mr. Upson, I don't want any mortality in an oral argument, but frankly, if that's a strict liability, if that is an unconstitutional strict liability criminal statute, then so is the child neglect statute, because they both revolve around a relational component, which necessarily gives rise to a mens rea. And you have a child, you're in care and custody of them. It is understood that you are going to take care of that child such that they will not, reading it now, to maintain their child's physical and mental health. Here, the pertinent section of 828.12 sub 2 concerns a person who owns or has the custody or control of an animal. That's the linchpin here, which then results in who acts or commits an inaction that results in unnecessary pain or suffering. So I mean, they both hinge around relational aspects, and in that regard give rise to mens rea, right?
Judge, and Nicholson, and this is going to go over my time, but in Nicholson relied upon by the state, which is a child abuse context, the state even argues in its answer, quote, one can willfully omit or neglect to do something that results in unnecessary or unjustifiable pain and suffering, just as one can willfully commit an act that produces the same result. It's almost impossible to talk about either without talking about knowledge. And in the felony animal cruelty cases, Brown and the Morial, I believe, upon which Brown, we're talking about skin and bone animals in cages with food and bags nearby, which in the child abuse context, we're traditionally looking at very different factual situations than a fat, happy dog that we have here.
At that, I'm going to cut you off, Mr. Upson. You and Judge Lucas went over your time.
Sorry.
So, all right.
Thank you.
All right. Thank you both very much. In order to leave the virtual courtroom, you need to click the leave button on your